Okay, so when employees refuse to return to work, you need to determine why the employee is refusing to return, because some reasons are legally protected, some will not be. Those declining to return to work just because they want to remain on unemployment are not protected. So yes, you can require those individuals to return to work, okay? Those declining to return to work because they have what is known as a generalized concern about contracting COVID are not protected, because that's all of us. I mean, we all have this general concern over contracting COVID, but that doesn't give us a ticket for special consideration. However, individuals that have a reasonable and more specific fear of contracting COVID may be covered because they have an underlying condition or anything that makes them more susceptible to complications from COVID. They're in a different category, as are those that might have a mental disability that causes a more extreme reaction to the potential of contracting the virus. So these would all need to be validated by the employee's doctor or their medical professional. So these situations need to be handled as any other request under the ADA and any other relevant state laws that might be in place. So here's another common question. Can you deny a reasonable accommodation request? Yes, you can. But here's something to keep in mind. The most common accommodation request for these issues are two things: telework and a leave of absence. And since telework and leaves have become almost the norm since this hit in March, I would be very careful about denying this as a requested accommodation. But once again, ADA issues are for your HR or your legal representatives to try to figure out. The Families First Coronavirus Response Act provides protected leave for various reasons: childcare, personal illness, quarantine, caring for others who have tested positive for corona, among a host of other things. These provisions apply for leave taken through the end of this calendar year. Some of these provisions apply to employers with less than 500 employees. There are some small business exemptions for those who have less than 50. So again, bottom line, seek assistance to navigate these regulations. And if you haven't already, just as a general tone, always try to set a culture, as Jeff was talking about earlier, where your business does its best to resolve any workplace issues, COVID or otherwise, because this may help you in the end. I mean, everybody's stressed out and not at their best, and you have to give consideration to these unique times that we're in. But this is going to help you in two ways. One, your employees' morale is going to remain as high as possible, and it helps build trust, so that's two. But the third help may come down the line, where it may help to insulate your business against any legal claims that your employees may think about filing, because they know that based on the culture that you've established, that you're really trying to do the best you can. And that, believe it or not, will reduce your possibility of your employees challenging through the courts. So I haven't mentioned anything about collective bargaining agreements or unions, because most, if not all of you, probably aren't unionized. And the last time I checked, the private sector union representation was hovering at about 7%. But if that is something that is in your work environment, then be sure to work with your union officials on all of your decisions. Not that they have to agree with them, but again, in terms of being transparent and being able to communicate effectively. And another quick note on employee safety concerns: if an employee claims their employer is not taking reasonable steps to provide a safe workplace, they may have a protection under the Occupational Safety and Health Act, or OSHA. And any complaints about lack of safety may trigger a whistleblower complaint, which means that as long as they follow the law, that they can make these complaints regardless of whether or not they're fair or foul, and they can have protection, and you can't touch them in terms of terminating them because they made those complaints. The only exception is if you have less than 10 employees throughout the year. So you have to kind of keep a running track on that, and then you're exempt from some of these record keeping requirements that OSHA requires. Here's a suggestion, and it's just a suggestion. Obviously, nothing legal is going to surround what I'm talking about next, but you may want to first try asking for volunteers before mandating that people return to work. Ask people whether or not they're comfortable returning to work, because there will, without a doubt, will be employees who won't want to return until this spike ends, right? But if you ask or direct employees to return to work and they refuse to do so, here's some things that you have to keep in mind. And I'm going to name three of them. One, document the date of your request that you mandated that they return to work. Two, what were the terms of the request? And then three, the specific reasons given by the employee for why they rejected the opportunity to come back to work, or the mandate, I should say. And to clarify what I mean about the terms they offer, this includes, was the return to work offer on the same terms and conditions as prior to COVID? Or did something about the job change? If so, you need to document in detail what those changes were, and then be aware that if an employee refuses to return to work to a job that is significantly changed, most likely they're going to be eligible for unemployment, because that's not the same job. So you're going to want to be able to document those things. But regardless, all of this information you're documenting is going to be helpful in case you choose to dispute any unemployment claims, or if the employee later on says that they were inappropriately or illegally terminated. Talk a little bit more about unemployment. All right, so we're seeing a lot of state unemployment commissioners or hearing officers. They're asking employers what they have done to keep their work environment safe. You need to be truthful, but you also need to be cautious about answering these questions, because this information can be the basis for a legal claim that you didn't do enough to keep your business safe for the employees. And we get comfortable in these unemployment hearings because a lot of times we've done a lot of them, okay? But you have to be on guard that an unemployment hearing is a legal record, and you're creating a legal record. So be careful not to get frustrated and accuse employees of either lying or malingering. Even if you think they are, don't have that come out of your mouth, right? And don't have that in any of your documents. And never, ever feel comfortable about revealing a former employee's medical condition, okay? Because this can also give rise to claims. So some of these hearing officers, they may ask for it in an open hearing. My recommendation, of course, 71% of you have those lawyers, which is good. I would respond by just saying, I'm not comfortable revealing an individual's medical information. And the hearing officers, sometimes they don't know any better. I mean, I hate to say that, but sometimes they don't know that maybe they shouldn't ask that question and then have you pronounce that information on the record, because it could violate HIPAA, even though it is a quasi-legal process. Instead, try to use the former employee's own statements where possible. For example, read an employee's email into the record about why they stated that they couldn't return to work, but again, without disclosing confidential medical or sensitive information. If the hearing officer asks for a copy of the email, and any good hearing officer will, then talk to your HR or your legal people, because 9 out of 10, what you're going to probably do is try to redact that information out of there, or it will be submitted from the attorney, not you, to the hearing officer that represents the state. When I was an HR director, I told managers all the time, the more you have to talk to defend your position or your actions, generally the worse the outcome is going to be, right? You let the documentation in these cases speak for itself, and that usually comes out with a better result. They didn't always listen, but this is another one of those processes where you should partner with your HR or your legal staff. All right, I'll wrap up this section with a few bottom lines. 1, when an employee refuses to return to work, you A, must inquire about the reasons, B, respond appropriately, and 3, properly document the issues. 2, don't stray from EEOC directives and CDC guidelines. If there's a conflict and you're talking about the workplace, listen to the EEOC, right? B, keep up with the changes. And C, coordinate with state and local public health officials. And most importantly, number 3, seek legal assistance wherever you can. And I'm not trying to start an employment agency for lawyers or anything like that, but these are not the easiest issues to navigate. And you're trying to run a business, so it's going to be difficult for you to be a business owner, entrepreneur, plus do HR, plus be the lawyer.